Oh, I am muted. Mr. Pointer, will you be ready when Mr. Busio is ready?
Yes, sir. Do I need a waiver for rain?
Has he been arraigned? Today was set for pretrial.
Today was set for pre-trial, I think,
Hang on, before we, I want to make sure he's in here before we go on the record on that. And we'll stay off the record for a second. Do you believe that he's been arraigned? Okay. Take a second to review. Yes, Mr. Pointer, you and he waived arraignment on August 5th. That was in cause number CR 2107. I'll check 106 as well. Yes, you waived arraignment in each case on August 5th. It was e-filed and signed by the court on August 6th. So as soon as he's back out, we'll call your guy. Mr. Wood, are you ready on anyone?
Judge, I just need to execute paperwork from Mr. Miller.
So some more time. You may.
This is the paperwork on Mr. Chris for this afternoon. He's the one that's in Louisiana.
Yes.
But I'm gonna go ahead and tender it to the board.
Okay, good. Thank you. Mr. Lucio, go ahead and come to the podium. Ready, Brandon? This is cause number CR 2106-107, State versus Xavier Alexander Lucio. Mr. Pointer, we're set for pre-trial today.
Yes, Your Honor. We were with respect to request a second pretrial setting. I haven't agreed with that. For that, we did not receive all discovery.
What are you lacking? Is it on there? Is it listed on there what you're lacking?
No, no.
We'll need to, right there in that box, it says discovery. If you don't have it, we need to list it there. So we have it in the record.
Judge, we gave Mr. Pointer, his having his contact information, he signed up for the online portal. Also notified him, we need to provide us with discs to get the video evidence.
So he doesn't have any discovery.
I'm aware.
When was Mr. Bucio indicted? He's been indicted for some time, hasn't he?
It's been well over a year, Your Honor. I just came in. It's August 6th or 7th.
Yeah. He was indicted in June. All right, court will set him for pretrial then. On Tuesday, October 3rd.
Set at 9 a.m.
It'll be at 9 a.m. He'll need to sign it. He'll need to sign and date, and then he'll get the yellow copy. Court will retain the white copy.
You said Tuesday, October 3rd?
Tuesday, October 3rd. I'm sorry.
Is that November 3rd, maybe? We won't have time to get discovered till October 3rd.
No, I'm sorry. Let's do Tuesday, October 6th. Hang on, Mr. Pointer. Yes, we'll keep it on November 3rd. November 3rd. Then, of course, according to the code, we'll have to have pretrial motions, any contested pretrial motions filed 7 days before that date. Any contested pretrial motions will need to be filed 7 days prior to that date in accordance with the code. So just for the record purposes, Mr. Bucio is set on November 3rd at 9 a.m. And Mr. Bucio, you signed your conditions of pretrial release. And you have a copy of those.
I do. Yeah.
Okay, good. You're free to go.
You just said November 3rd?
Yes. Yeah, I'm sorry, Mr. Pointer. Let me have his copy back. We need to change that date to November 3rd. All right, and so Mr. Pointer, you now know how to access the DA's office Discovery. They're going to give you the portal. Okay. Any issues with Discovery, make sure you're staying in contact with them so we don't have any more delays.
Correct. Thank you. Please excuse me.
Yes. Yes, sir. Free to go.
Thank you, Your Honor.
You come silence this phone. Please, man. All right, we're gonna do this Zoom here.
Good morning.
Good morning, sir. How are you?
Fine, yourself, sir.
Excellent. This is cause number CR 279, State versus Daniel Ray Garcia. Record will reflect that Mr. Garcia is appearing via Zoom this morning in the Galveston County Correctional Facility. Mr. Garcia, how are you, sir?
How you doing, sir? Doing good.
All right, Mr. Garcia, we were set for arraignment today, and I believe, and you help me remember, the last time we had a court hearing, we discussed your charges here in Van Zandt County, and I think maybe you discussed a little bit about your charges in Galveston County. My recollection is that you thought you were about to resolve your business in Galveston County. Is that correct?
Yes, sir. Then they had a hurricane, and it shut down the courts up here. So it was a status conference set for last month, but now we have it's the disposition, and that'll be on the 7th of October, in a few, next Wednesday, not this Wednesday, next Wednesday. So God willing, this will be it right here, sir. This is my first disposition. I've been here 8 months, so and I do have a hired attorney, and so we're looking forward to closing this out. It's a state jail felony, and then it's another possession of a deal. What do they call it?
Controlled substance,
No,
paraphernalia.
unauthorized item. They did a major shakedown, and they found a sharpened toothbrush that this guy had stuck under the table.
Okay, all right, well,
I'm
don't
just saying
test.
that. Yeah, so those are the two charges I have here. So my lawyer said that he already put in for time served. So
Okay,
that
all
was
right. So what I'm going to do for you then, Mr. Garcia, is you're in this court that you believe that you should have your Galveston County business resolved by October 7th.
God willing, yes, sir.
Just go ahead and stand up and bring that phone to the bailiff. Go ahead and stand up and bring the phone to the bailiff. Stand up and bring the phone to the bailiff. Ma'am, stand up and bring the phone to the bailiff. Sorry about that, Mr. Garcia.
Okay.
All right, Mr. Garcia, let's do this. I'm going to reset you for arraignment on Tuesday, October 13th, and we'll visit again. If you're still in custody, then we'll visit again via Zoom. And at some point, if you're not out of custody there, at some point, we'll need to discuss how you're going to resolve Van Zandt County business. If you are out of custody, then you're ordered to be here in Van Zandt County at 9 a.m.
Okay. Sounds good. Hope to see you on the 13th in Van Zandt County.
Van Zandt County at 9 a.m.
Yes, sir. Hopefully
Now,
I'll be there.
Now, listen, if you resolve your case and you're still doing time, let's say that you don't get a time served and you're still doing time in Galveston County, then we may have to make arrangements to have you bench warranted over. And if that occurs, we'll discuss it at that time as well on the 13th. Okay.
Okay, sir.
All right. So we'll see you soon either way.
Okay. Thank you.
All right.
Okay, see you then.
Gentlemen in Galveston County, thank you so much for your assistance today. I really appreciate it.
No problem, Your Honor. Thank you.
Appreciate it, sir.
You're welcome. You have a good day.
Good rest of the week.
He is in functions. Okay, thank you. Mr. Wood, are you ready? Or do you still need some time? I'm not trying to rush you. I just want to make sure I'm not.
I think I'm about to have all three of them ready.
That's fine. I'll give you time. I don't want to rush you. Just want to make sure I don't overlook you. Good morning, Mr. Adams. How are you? We'll be off the record.
Morning, Your Honor. I'm well. You doing okay?
I'm doing fine. I believe that your client is also logged into Zoom.
Okay, good.
Ms. Chevalier, are you there? Okay, Ms. Chevalier, I just want you to know that I don't have any audio for you. I can see you, but I don't have any audio, so.
She's right outside.
All right, Ms. Chevalier, we're going to go ahead and continue, and I may ask you to give me a thumbs up. Can you see and hear me? Okay, if you can't, give me a thumbs up.
I don't see a thumb.
Ms. Chevalier, can you see and hear me okay? Mr. Adams, are you trying to send a message to Ms. Chevalier?
Yes, Your Honor.
I have as well.
May not work from the desktop. Let me try this.
I'm going to do this, Mr. Adams. I'm going to put her back in the waiting room.
All right,
Will you try to give her a call?
surely, I'll do that.
All right, Mr. Wood, are you ready?
Ready.
Who are you ready on?
All three of us, start with Mr. Watkins and Mr. Porter, we asked him for additional time.
All right. You ready, Brandy? CR 1964, State versus Zanitrick Porter.
Just executed a waiver of jury.
Hang on, let's let her get up here. So, okay, go ahead, Ms. Porter, right there to the podium. There you go. All right, we're set for pretrial today.
Just executed a waiver of jury trial. We got a deal worked out with the state. I just not had opportunity to paperwork, so they was asking for a complete aid on that case.
Can I see the waiver? All right, Ms. Porter, if you will, raise your right hand. I'm going to place you under oath. Ms. Porter, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Make sure you speak into that microphone, Ms. Porter, okay? Because I want to make sure that I can hear you and that my court reporter can hear you, okay? And make sure you speak up. And bailiff, is that microphone on? All right. Is your name Zanitria? Okay, well, my docket says Zanitrick, so I'll make sure we get that changed. All right, Ms. Porter, I'm holding in my hand a document called Waiver of Jury Trial. And it tells me in this document that you understand that you have the right to have your case tried by a jury of your peers, that you have the right, that you understand you have the right to subpoena witnesses, the right to confront and cross-examine the state's witnesses, all in front of the jury. And that you also understand that you would be giving up all of those rights by executing a waiver of jury trial. Are you asking the court to allow you to waive your right to jury trial? All right, you look rather confused. Do you know what we're doing today? You don't? Okay, go ahead and have a seat. Mr. Wood will talk with you again in just a moment. Mr. Watkins. This is CR 20-201, State versus Michael Watkins. Just one moment, Mr. Watkins. Mr. Wood, Mr. Watkins is set for pretrial today.
So that just needs some additional time. Mr. Watkins to go over his discovery out there and brief communication with Mr. Cox, not having an opportunity to get Mr. Watkins. I'm doing that relatively soon. I can get 30 days, have something a little more substantial now.
You've been over his discovery, but he hasn't.
I think I've got
So there's no need for additional pretrial to raise contested pretrial motions, rather just setting for a docket call?
I think you're setting for adoption probably.
Okay. All right, the court will set Mr. Watkins for docket call on Tuesday, November 3rd at 9 a.m. And Mr. Watkins, while Mr. Wood is filling that out, you reported to the pretrial release department and you received a copy of your pretrial release conditions, correct? Can you understand what's expected and required of you? A white copy for court, yellow copy for defendant. And Mr. Wood, in CR 20117, the court has confirmed that Mr. Faulkner is in custody in the Hopkins County Jail. Do you have any information regarding his charges there?
I've never talked to his mother, but I've never get a hold of his Prince Attorney representation of Hopkins County. I think he'll be getting some time over there, on some felony cases.
All right, the court will reset Mr. Faulkner to November 3rd for pretrial and custody status. Also set at 9 a.m. Let's go ahead and fill out a notice of setting on that, so I'll have it in the clerk's record. And I'll let you keep the yellow copy, Mr. Wood. Okay. Are you ready on Ms. Miller? Ms. Miller, Sandra Miller, CR 20137. Here, Lee. This will also be in cause number 2020-333. And Mr. Wood, the trial court certification of defendant's right to appeal, did you discuss that with your client? Nothing's checked here. It's a plea agreement. I'll check it. I just want to make sure that you've discussed it with her. And probation conditions, do we have those? Has she gone over them? She has. Did you go over them with her?
Yeah, I didn't go with it. She's in.
Let's hold up and somebody to go over them with her, especially if she's gonna be on the mental health caseload.
Okay.
Somebody explain to her what, do
Let me just do that.
you want me to keep you here? I mean, or do you want some more time?
Just give me-
Okay, I'll hop somebody else. Mr. Perez. Pedro Manuel Perez, CR 2088. All right, and Ms. Cazares Perez, if you'll just state your name for the record and spell it for my court reporter, please.
Alexander Tavares Perez, CAZERANERES hyphen GMPR.
Thank you, ma'am. All right, Mr. Perez, if you will, raise your right hand. I'm going to place you under oath. Mr. Perez, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? Thank you, sir. All right, you may put your hand down. Make sure you speak up loudly and clearly, okay? All right. All right, you are Pedro Manuel Perez, is that correct? Are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Ms. Alexandria Perez Cazares. Are you pleased with her representation of you? You feel like you've had sufficient time to meet with her, discuss with her your case, and have all of your legal questions answered? Now, I thought I saw some hesitation in your response there. You kind of shook your head no, but you said yes. Sir? Very nervous. Okay, well, I can appreciate that. Ms. Perez Cazares, do you believe your client to be competent today?
Yes, I do.
And you have explained to him his legal and constitutional rights?
Yes, I have.
And you believe that he appreciates and understands the consequences of his plea?
Yes, I do.
Mr. Perez, you are indicted with a third-degree felony offense of unlawful possession of firearm by felon that carries a range of punishment of not less than 2 years nor more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment? Now, it appears to me that there is a plea agreement in this case in which you would plead guilty to that charge in exchange for the state's recommendation that your punishment be assessed at 7 years confinement in the Texas Department of Criminal Justice, a 0 fine, and that you have 3 other cases dismissed, those being unfiled cases of possession of controlled substance in penalty group 3, possession of marijuana less than 2 ounces, and theft of firearm. In addition, you would have court costs of $290 and reimbursement fees of $15, and you would receive 1 day credit towards that sentence for time you have spent in jail. Mr. Perez, is that your understanding of the plea agreement?
Yes.
And counsel, yours as well?
Yes, sir.
This time, Mr. Perez, how do you plead to that third-degree felony, unlawful possession of firearm by felon? And Mr. Perez, are you pleading guilty because in fact you are guilty and for no other reason? Has anyone threatened you, forced you, otherwise pressured you to plead guilty to this charge? All right, the court will accept the defendant's plea of guilt. Counsel, is there any objection to the offer of states one, the stipulation of evidence? All right, states one is admitted into evidence and the court will take judicial notice of Mr. Perez's judicial confession. Is there anything further from the state?
No, Judge, the rest are closed.
Anything further from the defense? All right, Mr. Perez, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement in your case. The court assesses your punishment at 7 years confinement in the Texas Department of Criminal Justice Institutional Division. The court dismisses under section 1245 of the Texas Penal Code, unfiled DA number 2020-138, possession of controlled substance, DA 2020-136, possession of marijuana less than 2 ounces, DA 2020-139, theft of firearm. Court assesses court costs in the amount of $290, reimbursement fees of $15. Mr. Perez, you are credited 1 day towards your sentence in this cause for time that you have spent in jail on this case. All right, Mr. Perez, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward with my bailiff to be fingerprinted, after which bailiff you're to take him into custody. I tell you what, come up here, we'll take care of our business and then the bailiff, we'll talk about that. It's all stapled together, so I'll just leave it that way. Okay.
Ready.
Bailiff. Move out there. It's gonna be your decision on whether or not you want him to be able to say goodbye to his family. However you want to handle that, if you want to do it at all.
Okay. Are you ready for the next case?
I have some that can call.
Okay. If we have a minute, I'll let him come up. I'm not gonna walk in.
No. Wouldn't do it. Do you want me to wait? Call, you go ahead and call other cases, wait for you.
If you're comfortable calling, we'll do that.
Well, I just want to give you time. I didn't want it to be, that's why I gave you time to do that, because I didn't want you to be doing that and then me calling up other cases and having to divide your attention, so.
I appreciate it. I think we'll
You're
be
good,
fine.
okay. Mr. Wood. Seisel. This is not her name on the indictment.
Judge, we made an oral motion to amend the document to reflect that change.
We did that at the last hearing, Judge.
Guess they just didn't, they don't scan it back in there. All right, so it's Anitria. Okay. All right. Guess they don't scan that back in there. I need to tell them to do that. Okay, she's good to go. She didn't look like she was good to go a minute ago. Gotta go slow. Gotta give me that heads up. Cause I thought you wanted me to go fast. Let me tell you.
You can go.
You're sending me mixed signals.
Judge, just look out for trouble.
Miss Porter. All right, Miss Porter, you understand that you're still under oath? Okay, I had you raise your hand and ask, remember I did that previously? All right, you understand that everything you tell me, you're swearing that that's the truth and you're under oath. Okay, all right, your name is Anitria Janae Porter. And Miss Porter, you're represented by your attorney, Mr. Jeff Wood, is that right? And you and Mr. Wood have discussed today this document that's called waiver of jury trial. Now, Ms. Porter, I'm sure that you and Mr. Wood have talked about it, but I want to talk about it with you also. You understand that you are accused of committing a crime. And you understand that you have the right to have your case tried by a jury of your peers. And that jury can decide whether you are guilty or not guilty of the accusation that's been brought against you. And you understand that you and only you have the right to decide whether or not you waive that jury trial. And before you can do that, I have to make sure that you understand that when you waive your right to a jury trial, you're also giving up other important rights. And those rights are the right to subpoena witnesses and confront them and cross-examine them in front of the jury. Do you understand that? Do you understand that once you waive your right to a jury trial, there's very limited circumstances in which that can be given back to you? And today, when you executed this document, did you do so because that's what you wanted to do? Did anyone force you, pressure you, tell you you had to waive your right to a jury trial? And you're asking the court to allow you to waive your right to a jury trial. Is that right? All right. The court finds that this waiver of jury trial has been joined by counsel for the defendant, Mr. Jeffrey Wood, and counsel for the state, Ms. Hillary Heisel. The court finds that it has been executed intentionally, knowingly, and voluntarily, and the court approves the waiver of jury trial in this case. And Mr. Wood, you've asked for some time to bring the case to resolution. Is that right?
That's very good. I'll be a whole lot of time. Next week. Next Tuesday, I want to.
And you're available on October 6th? That would be the next Tuesday. That's next Tuesday.
Should be.
You want to check your calendar?
Where my only issue, I'm thinking about getting together. We can maybe have a problem.
How about the 15th? That's a Thursday. Can you make a Thursday work? Let's set it for October 15th.
9 o'clock.
9 o'clock. Yes, Ms. Porter, we'll see you back on Thursday, October 15th. All right, Ms. Miller, Sandra Miller. All right, we're back on the record, CR 20137, 2020-333. You are Sandra Fulgham Miller, is that correct? Ma'am, if you will, raise your right hand. I'm going to place you under oath. Ms. Miller, do you swear that the testimony you give today to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. All right, Ms. Miller, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And and make sure when you answer, don't shake your head. Make sure you say yes or no so my court reporter can hear you and take it down, okay? All right, what have you been diagnosed with?
Severe anxiety and depression. And she said I told her that I don't know if it's
Okay. Are you currently on medication or seeking any type of medical treatment for those disorders? Okay. And are you on it? Are you on your medication today? All right. And do you feel like your medication has adjusted you and put you in a rational mindset today? You feel like you understand the proceedings that are going on today? And Mr. Wood, do you believe your client to be competent today?
I do not.
And Ms. Miller, you're represented by your attorney, Mr. Jeff Wood. Are you pleased with his representation of you? Do you feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered? Mr. Wood, you've explained your client's legal and constitutional rights to her?
I have.
And do you believe that she appreciates and understands the consequences of any plea before the court today?
I do.
Ms. Miller, you have two charges. The first charge is a state jail felony offense of possession of controlled substance in penalty group 1, less than 1 gram. And the other charge is driving while intoxicated, second offense, a class A misdemeanor. The range of punishment for a state jail felony is confinement in the state jail for not less than 6 months nor more than 2 years and a fine not to exceed $10,000. Do you understand that range of punishment? The range of punishment for a class A misdemeanor is confinement in the Van Zandt County Jail for a period not to exceed 365 days, fine not to exceed $4,000. Do you understand that range of punishment? Any sentence or plea agreement that's reached in this case must be within those ranges. You understand that? Now, it appears to me that there's a plea agreement in each one of your cases. In your state jail felony possession case, it appears that the state's recommending upon your plea of guilt that the case be reduced under section 1244B, that your sentence be assessed at 1 year confinement in the Van Zandt County Jail that sentence be suspended and you be placed on community supervision or probation for a period of 18 months, a $1,000 fine, $180 restitution, having an unfiled case, possession of dangerous drug, being dismissed, and you being placed on the mental health caseload through your community supervision. In your DWI case, the recommendation upon a plea of guilt is that your punishment is going to be assessed at 365 days confinement in the county jail, with that sentence being suspended and you being placed on community supervision for 18 months, with each sentence running concurrent with one another. That means at the same time. Is that your understanding of the plea agreement? And in that DWI case, you would have a $100 fine, $270 court costs. And Mr. Wood, is that your understanding of each plea agreement? All right, Ms. Miller, then I'm going to ask you, as to the possession of controlled substance, penalty group 1, less than 1 gram, how do you plead? And in your driving while intoxicated, second offense, class A misdemeanor, how do you plead to that charge? Ms. Miller, are you pleading guilty to each charge because, in fact, you are guilty of each charge and for no other reason? Has anyone threatened you, forced you, or pressured you to plead guilty to either one of these charges when you believe that you're not guilty? All right, the court will accept the defendant's plea of guilt in each charge. Mr. Wood, is there any objection to states 1, the stipulation of evidence in each case?
No objection.
All right, the court admits states 1 in each case respectively and takes judicial notice of Ms. Miller's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
Nothing from the defense.
All right, Ms. Miller, based upon the court's review of the evidence, the court will find that there is sufficient evidence to convict you of each offense. The court will follow the plea agreement that you have reached with the state. In your possession of controlled substance penalty group 1 charge, the court hereby convicts you under section 1244B of the Texas Penal Code. Court assesses your punishment at 1 year confinement in the Van Zandt County Jail. Court suspends that sentence and places you on community supervision for a period of 18 months, assesses a fine in the amount of $1,000, restitution in the amount of $180. The court dismisses under section 1245, unfiled cause M19-872, possession of dangerous drug. The court orders you to be placed on the mental health caseload as a condition of your community supervision. The court orders this sentence to run concurrent with cause number 2020-333. Court also assesses court costs in the amount of $290 and reimbursement fees of $685. Ms. Miller, in your driving while intoxicated charge, the court convicts you this day of driving while intoxicated, a second offense, assesses your punishment at 365 days confinement in the Van Zandt County Jail, suspends that sentence, places you on community supervision for a period of 18 months, orders this sentence to run concurrent with CR 20-137. Court also assesses a $100 fine, $270 court costs, and $15 reimbursement fee. Ms. Miller, do you have any questions about the proceeding today? You understand everything?
Yes.
You understand that you're going to be placed on community supervision, and you've gone over your conditions of community supervision with your attorney, Mr. Wood. Is that correct? So you understand what's expected of you. And you also understand what occurs if you violate the terms and conditions of your community supervision. Is that correct? All right, Ms. Miller, you're hereby remanded to the custody of the Van Zant County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step forward to be fingerprinted with my bailiff. After that time, you're to report to the probation department, okay? Mr. Wood, is that all you have this morning? Just point you in a direction right now. Mr. Head, are you ready? You only have, he's your last case, correct?
Yes.
Okay. CR 20-121, Quincy Hankins. All right, Mr. Hankins is set for pretrial today, Mr. Head.
Yes, sir, Your Honor, we just received a discovery a couple of days ago, Mr. Wine, and we wanted to ask if we could reset the pretrial, and get a little bit more time to review that discovery.
Any objection from the state? All right, court will reset Mr. Hankins for November 3rd. Any scheduling issues that day, Mr. Head?
No, sir, Your Honor. Would have election.
That is election day.
Your Honor, I did have one issue. He met with the bail supervision office today. And they had marked the indication on a court-appointed attorney. I am retained, so we just want to make sure that was clarified.
Yes, and I believe the condition says only if he's appointed does he have to pay, so that should be reflected in their records.
Yes, sir. And the other issue, Mr. Hankins has no prior criminal history. He lives out in the country. He actually possesses some firearms. It's my understanding this is a state jail accusation. We would ask that he not be restricted from possessing the firearms that he owns based upon the fact that he has no prior criminal history.
Ms. Heisel, Mr. Scott, any objection to Mr. Head is requesting that Mr. Hankins' condition of pretrial release regarding not possessing a firearm be modified at this time?
Yes, we did have an objection. It's our understanding that so long as you are under indictment for a felony, those rights are restricted for the pendency of the case. We would ask that not be limited.
Is there any allegation that there was a weapon used or found during this?
I don't believe in this case, Your Honor.
Is Mr. Hankins a concealed carry?
Your Honor, I know he has a hunting license. I don't know if Mr. Hankins has a concealed. I don't believe he has a license to carry. But I believe his criminal history, I think he's had a traffic citation in the past, if nothing else. There's no allegation of violence or resisting or anything indicating any sort of violence or any sort of weapon.
Court's going to deny the request to lift the restriction on the weapon, just as the court's policy of those being under felony indictment should not possess a weapon during the pendency of the case.
Yes, Your Honor. I'm not sure Mr. Hankins has any family member or friend that would place those with. Is there any chance that he could just ensure that those are locked up and out of? I just hate for, I don't know what it can do with those weapons actually, Your Honor. It's just hunting weapons from what I understand. If he locks them in a safe, that'd be sufficient for the court where he doesn't have immediate access to them.
That would put me in a position of defining possession. So possession would be care, custody, and control. So if it's locked up in a safe, I think it'd be the same as his money or anything else. He would still be in possession of that.
Yes, sir.
So I'll leave that to you and Mr. Hankins to decide how he can be in compliance.
Yes, sir.
All right, and we believe that all issues of discovery are complete at this time.
Your Honor, as far as I know, we have to see all of the discovery that's out there.
Thank you, Bailiff.
That's all I have, Your Honor.
Yes, thank you. Good to see you. All right, Mr. Hankins, we'll see you back on November 3rd, 9 a.m. Mr. Schmidt, are you ready?
Plea on Mr. Lee.
Then what about Huggins?
Huggins is here.
Okay.
Goss, I'm going to point this morning.
That's right.
And Goss, she's ready to go as well.
Okay. Did you get a copy of the indictment on Goss? It's tapering to give to you. Okay. Who do you want to call first? Your show. Goss. Miss Stephanie Goss, if you'll make your way to the podium. This is CR 20-163, State versus Stephanie Lynn Goss. Miss Goss, you have asked the court for a court-appointed attorney. The court has reviewed your information, has found you to be indigent, has appointed the Honorable Richard Schmidt to represent you, and you've had an opportunity to meet Mr. Schmidt with you this morning in court. Is that correct? And Mr. Schmidt, are you ready for arraignment today?
We are, Judge. We received a copy of the indictment, and I reviewed that Ms. Goss, her name is spelled correctly, and she understands what she's charged with, as well as things punishment. We would waive formal reading of the indictment and review of my guilty and ask the court to accept it.
All right, court will enter Ms. Goss's plea of not guilty into the record. And we will set this for pretrial. Do you believe November 10th would give you enough time to review discovery and file any pretrial motions? All right, Ms. Goss, therefore is set for pretrial on Tuesday, November 10th at 9 a.m. And Ms. Goss, have you met with the pretrial release department and received copies of your pretrial release conditions? Okay, then go ahead and have a seat over here and I'll have them bring paperwork to you. Officer Matura, this is Miss Stephanie Goss. She should have conditions of pretrial release. Kirkland Huggins, CR 20-125. Mr. Huggins is set for pretrial today.
That's correct, Judge. We've received discovery. We have no contested pretrial motions at this point in time.
All right, court will set Mr. Huggins for docket call on November 10th at 9 a.m. Yes, you're free to go. Yeah. Alicia Joyner, CR 20-127. Ms. Joyner is set for pretrial today.
Correct, Judge. Same motion. Received discovery. No pretrial contested.
All right, court sets Ms. Joyner for docket call on November 10th at 9 a.m. Weldon Lee. Cause number CR 20-84. All right, Mr. Lee, if you will, please, sir, raise your right hand. Mr. Lee, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can put your hand down. Mr. Lee, you are Weldon Kenneth Lee, correct? And Mr. Lee, are you a United States citizen?
Sir.
Do you read, write, and speak English? Sir, okay. Make sure you speak up loud enough for my court reporter here, okay? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you? And do you feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered? And Mr. Schmidt, do you believe your client to be competent today? You've explained to him his legal and constitutional rights. Mr. Lee, you have been indicted with the third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, less than 4 grams. The range of punishment for this offense is confinement in the Texas Department of Criminal Justice for a period of not less than 2 years or more than 10 years, and a fine not to exceed $10,000. Do you understand that any sentence handed down by the court by virtue of a plea agreement or otherwise must fall within that range of punishment? And it appears to the court that your plea agreement with the state is that you're going to plead guilty. State's recommending that your sentence be set at 10 years confinement in the Texas Department of Criminal Justice, with that sentence being suspended and you being placed on community supervision or probation for a period of 4 years, a $1,500 fine, $180 restitution. In addition, a few unfiled cases would be dismissed, specifically possession of controlled substance in penalty group 2, 4 grams to 400 grams, and a possession of marijuana less than 2 ounces. You would also have court costs, restitution, and reimbursement fees of $855 towards your court-appointed attorney fees and other reimbursements. Is that your understanding of the plea agreement? You believe it or you know it? Okay. And Mr. Schmidt, is that the plea agreement? Mr. Lee, any questions about any of that? You need more time to talk with your attorney, or are you comfortable with what you're doing today? You keep believing and you keep thinking, and I keep hesitating. Okay, so I want you to think about it. It's okay. I know sometimes this is phraseology in our speech, but I need to be assured that you're confident, because I don't want any buyer's remorse. All right, so is this the plea agreement you want to enter into with the state? All right, Mr. Lee, how do you plead to the third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams? You would be guilty? Are you guilty? Court will accept Mr. Lee's plea of guilt. Mr. Schmidt, any objection to State's Exhibit 1? All right, court admits State's Exhibit 1, takes judicial notice of Mr. Lee's judicial confession. Anything further from the state? From the defense? All right, Mr. Lee, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement in your case. The court hereby convicts you of the third-degree felony offense of possession of a controlled substance. Court assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. Court suspends that sentence and places you on community supervision for a period of 4 years. Court assesses a fine in the amount of $1,500. Court assesses restitution of $180. Court dismisses DA cause F19-611, M19-759. Court assesses your court costs at $290, restitution of $180, reimbursement fees of $855. Mr. Lee, have you ever been on probation before? Did you complete that probation or did you get revoked? You did what? You did complete it? So if it's not your first rodeo, you understand that if you're placed on probation and you violate the terms of your probation, you understand that the state of Texas can file a motion to revoke your community supervision. And if they prove to the court beyond a preponderance of the evidence that you violated the terms and conditions of your probation, the issue of whether or not you possess a controlled substance on this date will not be the issue. The issue before the court will be whether or not you violated your probation. You understand that? And if the court finds that you violated your probation, the court could assess your confinement in the Texas Department of Criminal Justice up to the maximum 10 years. You understand that? Do you have a drug problem? If you have a drug problem, now would be the time to get that figured out. If you need help, you need to tell someone you need help. Understand? All right, Mr. Lee, you're hereby remanded to the custody of the Van Zant County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you step forward to be fingerprinted with my bailiff, after which you're to report to the probation department through these doors. Okay? Once she signs her conditions, she's free to go. Mr. Smith, is that all you have? Okay.
I'll be back in a second.
Yes, sir. All right, we'll call the 10:30 cases with Mr. Platten. He's getting connected to Zoom right now, so. I'm gonna call the 10:30. Yes, Mr. Severs. Mr. Platten, can you see and hear the court? Okay, I believe you're on mute. You'll have to.
There we go.
There we go. All right. All right. I'm going to go ahead and call your in-court case first. Mr. Severs. Mr. Severs, come on up, sir. Mr. Severs, can you see your attorney, Mr. Platten, here on the screen? Maybe a little small, but
Oh, I see him back there.
see if I can.
Is he at a podium?
Does that help? Okay. All right. This is cause number CR 20-36. And we are set for a docket call today, Mr. Platten.
Yes, I was talking with the state about this yesterday, and I believe that we're going to get this resolved soon. There is one person that they need to speak with to make a determination in how we're going to proceed.
Ms. Heisel.
That's correct, Your Honor. The victim in this case delivered an affidavit of non-prosecution to our office. However, we've been unable to contact that victim and speak with them about their wishes regarding trial. So we would ask for one more docket call on this case.
All right, Mr. Platten, would you be available on Tuesday, November 10th? Do you have any scheduling issues on November 10th?
Take a look here. Not at this time, Your Honor. It looks to be okay.
Okay, then we'll set Mr. Severs then for an additional docket call on November 10th at the same time, 10:30 a.m.
Okay.
All right, Mr. Severs, you're free to go. We'll see you back on November 10th at 10:30. All right, let's see. We also have Mr. Tomas Smith. Mr. Smith, if you can unmute yourself.
Can you hear me, sir?
Yes, I can see and hear you. And Mr. Platten, can you see and hear your client okay?
I can, Your Honor.
Okay. All right, Mr. Smith, this is CR 19-275. Record will reflect that Mr. Tomas Smith is appearing via Zoom today. We're set for docket call. Is there an announcement, Mr. Platten?
Yes, the state has offered us to handle this as a misdemeanor, Your Honor. I didn't know if that was going to be in your courtroom or if it would be done down the hall.
It'd be in here. If it originated in here, I've got obviously jurisdiction over misdemeanor cases as well, so we could just plead it out here.
Okay. Would the 10th be good for that as well? Well, can that be done via Zoom too? I mean, I've done some pleas via Zoom.
It can be done via Zoom if the paperwork is signed and fingerprinted and submitted to the court in advance of the hearing.
Okay. Only other thing I've seen once, well, how they're doing it sometimes is getting everything signed off, and then when they report to probation, they're fingerprinting them at that point. Would that be okay with the court if the paperwork were done like that with the fingerprints after the plea at probation?
No, I want the fingerprint when I do the judgment.
Okay.
Do
So,
the judgment, or we can do an addendum. We can just have him, we could have him report to probation and be fingerprinted beforehand.
that's fine.
That way it's all done.
Yeah.
Or Mr. Smith can appear in court that day and you could appear via Zoom.
All right, be fine too.
Okay. So any objection to setting this for plea on November 10th?
No, Your Honor, I would just ask that Mr. Smith appear in person for ease and convenience for everybody, but we have no problem executing paperwork ahead of time and setting that.
All right. So what we'll do is we'll have Mr. Smith appear in person for plea on November 10th at 10:30 a.m.
I didn't hear all the content of her statement.
She said she has no objection to November 10th. However, she would request that Mr. Smith appear in person to be fingerprinted for ease.
That's fine.
So Mr. Smith, you will appear in court on that day, November 10th at 10:30. And
10:30, you said?
10:30, yes, sir.
Okay.
And Mr. Platten will be in contact with you about your plea papers. You'll have that worked out with him. And then we can get your fingerprint that day when you resolve your case. All right. So Mr. Smith, this will be the only notice you get from the court, November 10th at 10:30. Okay.
Yes, sir. Thank you.
All right. Now you're free to go.
Thank you.
You're welcome.
Bye-bye.
All right. Court calls CR 2139 and 140, Mr. Reisner. And Mr. Reisner, ask him to start his video.
There he is.
All right, Mr. Reisner, there you go. Mr. Reisner, can you see and hear the court okay?
Yes, sir.
And can you see and hear your attorney, Mr. Platten?
I can hear him. I'll have to, let me change pages so I can see him. Yes, I see him.
Okay, good. All right. All right, this is CR 20-139-140, and we're set for pretrial today, Mr. Platten.
More status, Your Honor. Some of the stuff that was uploaded to the discovery portal only showed a few pages. My assistant said that she printed out a little bit more and that there is some, I believe, audio or video footage we need to get from the district attorney's office. I believe we're here on 2 different cases, and it's going to be rather involved.
Okay, give me just one moment. So you're requesting an additional pretrial setting?
Yes, I think we can have that figured out by November 10th, Your Honor.
Any objection from the state?
No, Judge, however, I was unable to hear what Platten still in need of. I couldn't hear him.
He said that there was some, he said that his staff got onto the discovery portal and there was some things loaded up, believes that there's more to print out and that there's some digital evidence that they have to provide your office with.
That's correct. And it's a USB. There's no disk. It's USB.
Did you hear that, Mr. Platten? It's a USB, not a disk.
Okay.
All right, then Mr. Reisner is set then for pretrial at 10:30 on November 10th in each case.
Thank you, Your Honor. Can he appear by Zoom as well?
Yes, he can appear via Zoom that day.
Thank you, Your Honor.
All right, so Mr. Reisner, that is the only notice that you're going to get regarding your next court setting, November 10th at 10:30 a.m. Do you understand?
Yes, sir.
Okay, all right, you're free to go.
Thank you, Judge.
You're welcome. All right, Mr. Platten, is that all your clients? And yeah, I guess it is. You're gone. You're gone. Mr. Green, are you ready?
I'm not.
You're not?
We're
Okay.
not set to 11.
I'll give you 9 minutes. Mr. Sanders, do you need some more time?
No, Judge, I think I'm ready.
You sure? I don't mind. I'm not rushing you. Just,
I think we should be good.
okay. Randy, do you need a break? Are you okay? All right, before we call, I'm going to call Mr. Adams just real quick on Zoom. All right, Ms. Chevalier, are you there now?
Yes, sir.
Excellent. Okay, good. All right. Mr. Adams, sorry about the delay in that.
That's all right, Your Honor. I was late logging in earlier this morning, so.
All right, this cause number CR 18467, State versus Brandy Michelle Chevalier. Record will reflect that Ms. Chevalier is appearing via Zoom today. Court's permission for pretrial. Any announcement on pretrial, Mr. Adams?
Your Honor, we don't have any pretrial issues for the court to take up. I would advise the court that we recently received a plea offer for Ms. Chevalier. I've passed that on to her just yesterday. I also, as of this morning, obtained information that I did not have until this morning about her criminal history. And so she and I need some time to discuss her options in light of what the state's plea offer is. I will probably also be pestering the state again about the plea offer. And so essentially I'm asking the court to reset us, to give us time to do those things.
All right, rather than resetting for pretrial, the court will find that there's no contested pretrial motions at this time, and we'll set Ms. Chevalier then for docket call.
Very good.
And we'll set Ms. Chevalier for docket call on November 10th at 9 a.m.
All right.
Ms. Chevalier, this will be the only notice that you receive from the court of your next court appearance, November 10th at 9 a.m. You understand?
Yes, sir.
All right, make sure you stay in contact with your attorney, Mr. Adams. And you're free,
Okay,
you're free to go.
thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. Is that all you have, Mr. Adams?
It is on this morning's docket, Your Honor, and I have two this afternoon. I'll be present live and in person for those.
All right, thank you, Mr. Adams.
Thank you, Your Honor.
All right, Mr. Sanders. Let's see what we have here. Mr. Hazelbaker. Cause number CR 19-141. All right, Mr. Hazelbaker, you are Ty Allen Hazelbaker, is that correct? Please raise your right hand. Mr. Hazelbaker, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. All right, Mr. Hazelbaker, make sure you speak up loudly and clearly into that microphone so my court reporter here can take it down. Thank you, Mr. Sanders. And that the end of that will tip up if you need it. There you go. All right, Mr. Hazelbaker, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you? Feel like you've had sufficient time to talk with him about your case and have all of your legal questions answered? Anything about this plea agreement you don't understand? Mr. Sanders, do you believe your client to be competent?
Yes, Your Honor.
And that he understands and appreciates the consequences of his plea agreement?
Yes, Your Honor.
Mr. Hazelbaker, you were originally indicted with the third-degree felony offense of assault of a family or household member by impeding breath or circulation. However, it appears that there is a reduction of charge in a plea agreement. You were originally on probation for this, is that correct? So on October 22nd of 2019, you pled guilty to the Class A misdemeanor charge of assault causes bodily injury of a family member. The court heard the evidence, deferred a finding of guilt on that date, and placed you on community supervision for a period of 2 years. It was during that period that the state filed its motion to adjudicate and revoke your community supervision. They filed that on March 12th of 2020, and they alleged that you violated in 6 separate counts. Have you had an opportunity to review that motion to adjudicate with your attorney, Mr. Sanders? And Mr. Sanders, does your client waive the formal reading of the state's motion to adjudicate? All right, so Mr. Hazelbaker, it appears that you're going to be pleading true to all counts in which the state is then in exchange going to recommend that your community supervision be revoked, that you be adjudicated, convicted of this offense, have your punishment assessed at 32 days confinement in the Van Zandt County Jail. You'll receive 2 days credit for time served towards that sentence. You'll be ordered to pay the balance of your financial obligations. and you will be required to submit to the Van Zandt County Jail on October 16th, 2020 by 6 p.m. to serve out the remaining 30 days on your sentence. Is that your understanding of the plea agreement, Mr. Hazelbaker? Yours as well, Mr. Sanders?
Yes, sir.
Mr. Hazelbaker, then, as to counts 1, 2, 3, 4, 5, and 6, how do you plead to those counts? Are those counts true or not true?
True.
And are you pleading true because those counts are true and for no other reason? Has anyone threatened you, forced you, or pressured you to plead true to any of these counts?
No.
All right, the court will accept the defendant's plea of true. Mr. Sanders, is there any objection to the admission of the defendant's waiver of rights and plea of true?
No.
All right, court admits the defendant's waiver of rights and plea of true into evidence and takes judicial notice of Mr. Hazelbaker's judicial confession. Is there anything further from the state, from the defense? All right, then based upon the evidence before the court will follow the plea agreement in this case. Court finds that Mr. Hazelbaker has violated the terms and conditions of his community supervision. The court finds all counts to be true. Court hereby convicts Mr. Hazelbaker of the Class A misdemeanor offensive assault causes bodily injury of a family member. Court assesses his punishment at 32 days confinement in the Van Zandt County Jail. Court issues him credit for 2 days of time served and orders him to pay the balance of his financial obligations. The defendant is ordered to present himself along with a photo identification to the Van Zandt County Jail on October 16th of 2020, no later than 6 p.m. to be incarcerated to serve out the remainder of his sentence. Mr. Hazelbaker, did you and Mr. Sanders discuss what occurs to you if you do not show up on October 16th? And tell me what that discussion, how that discussion went. And do you know that your failure to appear when you're ordered to appear could result in a new charge of escape being filed for you? And you would have more than just one problem. You understand that? And Mr. Hazelbaker, are you going to be taking care of your financial obligations today, or how are you going to resolve what you owe the county? Then what I'm going to do is order you today to report to the court compliance officer at the end of the hall on your left. Meet with Miss Bonnie LaPrade to discuss setting up that payment plan. Your failure to uphold any agreements on your financial obligations and your failure to pay will result in the court issuing a warrant for your arrest. All right, Mr. Hazelbaker, hereby remanded to the custody of Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. I'm going to have you step forward to be fingerprinted with the bailiff, after which you'll need to make sure you get a copy of your judgment and present yourself to the jail with your photo ID. If you show up without a photo ID, they're not going to let you in. They don't let you in and you don't do what the court tells you to do, you're going to get that charge filed on you. Okay, step forward. Mr. Sanders, who are you ready on next? CR 20-1110, State versus Jason Cravey. Go ahead, sir. Mr. Cravey is set for pretrial today.
Judge, we've gotten the discovery, we had a chance to go over the written discovery. There's quite a few videos I haven't had a chance to go over with you. I was going to ask if we would reset for another pretrial. We're going to plan to meet this week to go
Any objections from the state? All right, the court will set Mr. Cravey for an additional pretrial on November 10th at 9 a.m. And before Mr. Cravey leaves today, I need to have him report to the pretrial release department. Mr. Cravey, are you aware that there are conditions of pretrial release that you must abide by?
Yes.
Have you received and signed a copy of those? Okay, then when you leave, I want you to come over and have a seat, and then Officer Mature will be with you, go over those conditions with you. Once you sign them and get a copy, you'll be free to go. Landon Musgrave, CR 2087. Mr. Musgrave is set for docket call today.
And Judge, still been talking with the state some, trying to get this case resolved. I was gonna ask if we could reset the one for Dr. Collins. We'll have a decision. Sure that.
Any objection from the state? All right, court will set Mr. Musgrave for docket call on November 10th at 9 a.m. All right, Mr. Musgrave, you're free to go. We'll see you back on November 10th. Is Timothy Nelson here? Timothy Robin Nelson is not present in the courtroom and was not present at 9 a.m. when his name was called either. Jose Vela? This is cause number CR 20143.
Hey, Judge, Mr. Bailey, I know we're set for pretrial. They have to ask me to reset for the pretrial. We still gotta go over discovery, considerable amount of discovery. Talking to the state some, we're still getting off for their, I think, several co-defendants. Still getting off for the state case.
Any objection?
No, Your Honor.
All right, court sets Mr. Vela for an additional pretrial on November 10th. Is there anything that you're lacking in discovery, Mr. Sanders?
Judge, I think I have everything. I've got the written stuff printed out. I think all the audio video recordings are online, so it just matters.
All right, Karen White. This is in cause numbers CR 20-68, 69, and 233. All right, Ms. White, if you will, raise your right hand. I'm gonna place you under oath. Ms. White, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. You are Karen Juanita White. And Ms. White, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you? Feel like you've had sufficient time to go over your case and have all of your legal questions answered? Anything about this plea agreement you do not understand? Mr. White, is your client competent today?
Yes, sir.
And did you explain to her her legal and constitutional rights?
Yes, sir. And just let the court know, I think on this particular case, the ratchet except for arraignment, we would waive the formalities, arraignment, and the indictment and purpose. And the other two cases that were on the docket are going to be voted by.
Okay, well, and you do waive the formal reading of the indictment in this case, and her name is spelled correctly in the indictment?
Yes.
Thank you for that, Mr. Sanders. All right, and Ms. White, you are charged with a second-degree felony offense of possession of a controlled substance in penalty group 1, 4 grams to 200 grams. The range of punishment for that offense is confinement in the Texas Department of Criminal Justice for a period not less than 2 years nor more than 20 years, and a fine not to exceed $10,000. Do you understand that any sentence handed down by this court by virtue of a plea agreement or on a motion to revoke your community supervision has to fall within that 2 to 20 range? And I see that you've reached a plea agreement with the state wherein you're going to be pleading guilty to that offense. In exchange, the state's going to be recommending to the court that the court review the evidence, defer a finding of guilt in your case, place you on community supervision for a period of 6 years, assess a $2,000 fine, $180 restitution, and you would have several cases dismissed under Section 1245 that are currently either indicted or unfiled. In addition, as a condition of your community supervision, you would have inpatient drug rehab decided at a later date. Is that your understanding of the plea agreement? And yours as well, Mr. Sanders?
Yes.
Ms. White, how do you plead to that second-degree felony offense? And are you pleading guilty because you are guilty? Has anyone threatened you, forced you, or pressured you to plead guilty? All right, the court will accept Ms. White's plea of guilt. Mr. Sanders, any objection to States 1? States 1 is admitted into evidence. The court takes judicial notice of Ms. White's judicial confession. Is there anything further from the state?
Yes, Your Honor, you described the condition of probation, why it would be inpatient treatment of some type. The reason that we don't have that decided today is because White has already applied to a couple of programs and requested that she apply to one more. As soon as she gets accepted to a program, and we know a specific program, we will bring it before the court to amend those conditions with a specific program.
Thank you, Ms. Heisel.
And then that's all the state will have this time around.
Anything further from the defense? All right, Ms. White, based on the evidence before the court Court will find there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement. Court hereby defers the finding of guilt, places you on community supervision for a period of 6 years, assesses a $2,000 fine, $180 restitution. Court dismisses under section 1245 the various charges contained in the judgment. Court assesses court costs of $290 and orders you to pay reimbursement fees to Van Zandt County in the amount of $1,085. Court orders that you attend the appropriate drug rehab as decided by the Van Zandt County Community Supervision and Corrections Department. Court also finds that there's been an agreement between the parties in SF 19-4, State of Texas versus $520. And Mr. Sanders, you do not represent her in this case, is that correct? And Ms. White, it is your agreement to forfeit any interest you have in the contraband that was seized? All right, the court has signed the agreed judgment of forfeiture in SF 19-4. Court this date has also signed the orders of dismissal in CR 26-8 and CR 26-9. All right, Ms. White, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you step forward in just a moment to be fingerprinted with the bailiff. After that time, well, that's what we need to discuss. So Mr. White, or I'm sorry, Ms. White, when you appeared in court today, the court was notified that you have several warrants. 2 of them were for cases that you have resolved today. So those would no longer apply to you. However, the court was notified that you have 4 other warrants unassociated with any of these cases, I believe possibly in Henderson County. I believe it was Henderson County. Is that correct, bailiff?
I'll have to give them information. They're going to be Van Zandt County warrants, but they're unassociated with this document today.
Oh, they are Van Zandt County warrants? Okay.
Judge, I think it was our understanding this was taken care of everything because she was released from Henderson County because everything in Henderson County was resolved. And Van Zandt County released their holds on her a week or so ago. But they were holds for, I believe, all these cases that the ones she pled to were all the other ones that were considered. So we were, back when we checked with the state.
Well, this is what
we had everything covered.
This is what we're going to do. We're going to have her come up. We're going to have her be fingerprinted, and then you'll just have a seat, and then we'll determine that warrant issue. If there are these warrants associated with these cases, then you'll be free to go. If they're not, then you'll be taken into custody. So we'll have you get fingerprinted, and you'll have a seat. Once we resolve that issue, then one way or the other, we'll discuss that with you. So come on up and be fingerprinted with the bailiff, and then just have a seat, and we'll keep on working. We'll figure it out, okay? Rena, you ready?
We're ready.
CR 15-487, State versus Sean Palmer. Mr. Green, I believe we're set for motion to adjudicate today.
That's correct, Judge. And Mr. Cox and I have an agreement such as your approval that if that Mr. Palmer would take your analysis today, and if he passes it, the state would be agreeable to resetting this to allow some time for the state to determine what their recommendation would be to adopt a short.
My only concern is Mr. Palmer's, this is his 9th setting on this motion to adjudicate by my count.
I suspect that, and I don't know, Judge, I know I got into the case, I think maybe in July, I don't remember the exact day. And we should work towards a resolution for this that would not require a hearing and bring it to the same.
That's my recollection as well. I believe Mr. Palmer and another attorney before Mr. Green substituted in over the summer.
All right, the court's not going to drug test him today. Probation may, but the court's not going to drug test him. Rather, we'll set him for evidentiary, or we'll set him for a contested hearing on October 22nd. So that'll be a meeting you halfway. You'll get a reset today, but on the 22nd, it'll either be a hearing or some type of resolution.
And what time you're on?
That would be at 9 a.m.
Will you be free to go?
Yes, he's free to go.
Thank you.
Mr. Palmer, you can stay in here if you want to. You're free to go. You don't have to go. Will it be the same announcement on red?
Yes, sir.
It'll be the same announcement for the court. CR 15-503, Tanya Red. Court will set Ms. Red for contested hearing on October 22nd. Yes, you're free to go. And that's also at 9 a.m.
Yes.
The ones that we don't, how does that work? What if I go to the jail, or they come here? I think
You'll go to the jail. Yeah. You'll go to jail. Yeah, they go to jail. They'll go to the jail. They've been going to jail. You'll go to jail. Aaron will be over there. It depends. Are you like asking if they like this one? Yeah, I think Stephanie knows the paperwork. It's probably the question. I don't really know. Usually the only ones that are here are me. Oh, here you go. This is a rundown. But yeah, Karen's usually over there. I thought she told me, John.
No problem.
Mr. Sanders, do you have anyone else?
No.
Okay. Your name, sir? Okay, that's fine. That's fine. It's okay. He's the only one that didn't show that I had like a nice eye by, I think, so. Oh, there's Timothy Nelson. And I don't need this on record. Jeff, Aaron, did we get the warrants figured out?
Yes, sir.
Where are they on these?
2 of 5.
There was,
2 of them initially were on.
right, these other 4 were these for the other 4 cases that would have appeared on docket that were resolved today.
No, sir, they're not on this docket. They're M numbers and F numbers.
Right, they're not on the docket, but in the judgment.
I think there was the only one that was a criminal mischief that didn't have in there that had been filed. I think we got that resolved too, where he was getting that taken care of.
So is she still around? Are we taking her? Are we
We're
leaving?
not taking.
We're not taking her.
It'll
Okay.
sit when we're done with all the charges that are being resolved.
Okay, good. Yes, sir. Thank you. Hey, Mr. Green.
Hello. Are you, is this the last time I see you? No. Oh, I thought you were, no, off the